Just like a natural person can borrow, a company can actually borrow against its assets, only that it has to be registered. This is day 11 of the 30 days Know Your Karma challenge. Listen, you would ask, how did we get here? We just said day 8 in the last post and we're on day 11. Day 8 tried me, it tested me, it made me ask myself, who sent you? But you know, one thing that we don't do here, we don't give up. Because if I'm doing it for just one person, and that person is the one that you're looking at right now, me, then we'll continue until we get to day 30. We're skipping day 9 and 10, and we're following the pace because we must finish this on 31st March 2026. So the only thing is that we're going to now put in more sections that we're supposed to do on 10 and 11. Sorry, on 9 and 10 into other parts of the days. So we continue, we move. Let's go. Today we're talking about registration of instruments, which the company actually brought. It actually hurt and pained me the fact that I actually took my time to explain the venture on day 8. And when I was editing and I saw that that part of the video did not record, I wanted to cry, but no. So I'll just, take my time to just go through it again because that's like the foundation of what we're talking about today. It's continuation of the 8th conversation, some of the parts which did not record. And sections 191, even though we're looking at sections 215 to 234 today, let's just go back to sections 191, which talks about the power to borrow so that you understand what we're saying better. And then just to add that we're going to change the modalities of how we do things around here. So we've been looking at the sections, addressing them one by one, moving to the next, moving to the next. No, that's not working because I sat down to watch some of the videos after I edited them and posted, and I'm like, ugh, somebody whose attention span is very limited may not have the patience to, and somebody who is still struggling hearing sections, this section, this. So what we're going to do is that we're going to lump all of the sections, address what we're discussing, address and discuss it, right? Just refer to sections as may be necessary and just go on. I think that works, right? And that helps people who are not lawyers, who are not law students, who are not exam students, who are following this to understand what we're saying better. So let's go. Today we're talking about um, registration of instruments, of charges, debenture, and all of that. But first of all, before we get there, let's see how we got there or how we will get there. Sections 191 says a company may borrow money for the purpose of its business or object, right? And may mortgage or charge its undertaking, property, and uncalled capital or any part thereof, and issue debentures, debenture stock, and other securities, whether outright or as security for any debt, liability, or obligation of the company or on any third party. And like I explained, which you did not know because it didn't record, a debenture is like an instrument that a company gives and says, I'm owing you. This is my evidence that I'm owing you. This is your evidence that I'm owing you. And I promise to actually pay you back with any interest as agreed by both of us. So that debenture is like your instrument that you give to the person who you are borrowing money from to say, this is your evidence that I've collected money from you, right? And I'm going to pay you back. But if I don't pay you back, there's so many things that are contained in the debenture, and it's just there in sections. I think sections 193 or so. Yeah, sections 193 in statement of to be included in debenture. So you can check it out. Now we move to the business of the day sections 219 to 234. Charges and debentures, right? So let's move. Once a company shall keep every copy of any instrument creating any charge. By charges, we mean any instrument creating any charge on any property, undertaking, or fixed or floating charges, any instrument of such nature that is required to be registered with the Corporate Affairs Commission should kept at the registered office of the company. The register of such charges should also be kept, stating, the type of charge. Is it a fixed charge? Is it a floating charge? Just give a short description on the assets, the amount of the charge, and all other information as may be necessary and as stipulated in sections 216 of CAMA. Remember that once CAMA states a thing, if you do not do it, there's penalty. Sections 216 up to provides for that penalty. Of course, you know that once a register is kept of anything, it has to be accessible to the members, sometimes for a fee, sometimes without a fee. In this instance, for the register of charges. It has to be available for the members or any creditor without a fee. And every other person that does not fall within this category can inspect subject to a fee that has been determined by the CAC. We talked about charges, then we move on to debenture. Company which issues or has issued debenture shall also maintain a register of the holders. That's the register of the debenture holders. And you know that kind of register would contain the name and address of the debenture, the principal of the debentures held by each of them, the amounts, and all information as may be required and outlined in sections 218 of KAMA. Once a charge has been created, sections 222 provides all that is needed to be known in terms of registration of charges created by a company. And one of the important things that we need to know is that once such charge has been created, it is mandated that the company would register or file the notification of such charge within 90 days to the Corporate Affairs Commission. Sections 222 is a lot. I think it has up to like 14 subsections, right? And it just talks about how this charge should be managed if the property that we're talking about is in Nigeria and this charge needs to be registered outside Nigeria. What if the charge has been created outside Nigeria? What if the property that is being referred to is outside Nigeria? All of those things are being provided for and covered in sections 222. Next is the certificate of registration, section 223. Once a charge has been registered under this part at the Corporate Affairs Commission, the Commission shall issue a registration certificate setting out the parties to the charge, the amounts, such other particulars as the Commission may consider necessary. And the certificate is prima facie evidence of due compliance with the requirements of registrations under this part. Having registered these charges, you may ask, when the company fulfills its obligation and pays the money, what happens to the property? Is that's where section 229 comes in. So if the commission is actually satisfied that the debt for which the charge was given has been paid or satisfied in whole or in part, then it would then register a memorandum of satisfaction to the extent necessary in terms of if it has paid in full or in part. Now, we talked about this registration to be done in 90 days. What if somebody was not able to, maybe they didn't know, or maybe they knew, or it was beyond their powers, or, something just happened and they couldn't register within 90 days? What do they do? Sections 230 addresses that. They approach the courts. Next is the realization of security. That means if I borrow money as a company from persons A and I'm not able to repay back, and persons A has said the timeline for my payment, which in this case I think is 1 month. After 1 month, I've not paid my money. I fail to fulfill the company. Let me stop using me. The company fails to fulfill its obligations, or under any circumstance, the debenture was created. The company is not able to fulfill any of those obligations. The debenture holder then says, I want to realize my security. What should this person do? The person is actually entitled to realize any security that is vested on him or on any other person on his behalf, having stated all of this. And if the company is even winding up and the debenture holder says, hey, this is my security at risk, this is one of the remedies, the realization of the security that are available to the debenture holder. The next is that they can approach a court for repayments or enforcement of the security, or commence a winding up proceeding against the company. So in a nutshell, let's just see it this way. Company has powers to borrow money, but when they borrow that money, they have to give an instrument, which we have seen as debenture stock, whatever it is, as a security to the person who they are owing. That person then holds this security, which should be registered within 90 days. If I fail to register it within 90 days, I can approach the courts and seek for an order for extension of time. If I pay my debts, what are the next thing available to me? We see the memorandum of satisfaction. And then if I even fail to pay my debts and I cannot pay, what are the remedies available to the debenture holders? That's all we have looked at in sections 216 to 234 today. I'll see you tomorrow.